Exceptions to Restrictive Covenants, Part 3. I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. Now, this third exception that we are going to examine today relates to what the courts call restraint of trade. Now, this is the thing that typically can trip an employer up when they're putting a restrictive covenant in a contract of employment or a settlement agreement that prevents you from working in your chosen industry in the future. So if there is a non-competition clause that says that you can't work for a competitor full stop, then that might not be legally binding, because how are you supposed to earn your income otherwise? Now, what we're going to discuss today is an extension of that. So it might be a clause in that contract of employment or settlement agreement that essentially says that nothing in the contract of employment or the settlement agreement prevents you from going and working for a business or in an industry that has absolutely nothing to do with your employer, your then former employer, or the industry that the former employer works in. So making it quite clear that it's not preventing you from working in any other industry that has nothing to do with it. So that's covered off the exceptions that we're going to discuss. There might be others, but in the weeks to come, as a famous comedy team used to say, and now for something completely different. So stay tuned for other bits and pieces on restrictive covenants. But in the meantime, if you're finding a settlement agreement hard, bring it to Richard.